So now I want to continue with this idea of limiting civil liberties. When do courts permit the federal government and the state governments to limit our civil liberties? And so I want to talk about a couple different things. First, I want to point out that all our civil liberties and all our civil rights are conditional, right? And what I mean by that is that, like, we have freedom of speech, but I think, as I said in previous lectures, although we have freedom of speech, we can't go into a theater and yell fire, right? Because our freedom of speech is conditional. There are conditions on it. It's not unconditional. And so the question is, if it's conditional, what are those conditions? When is the government permitted to limit our civil liberties? And this is also true of sort of interfere with civil rights. And that is that the courts will permit federal government and the state government to limit rights and liberties when the government can demonstrate that it has a compelling interest. A compelling interest. And that's the actual language they use in law cases, compelling interest. But the best way to understand it is just compelling interest means a really, really important reason. And so, for example, when it comes to freedom of speech, yes, you have freedom of speech, but can you yell fire in a crowded theater? No, you cannot, not just for kicks at least. You can't yell fire in a crowded theater because the government has a compelling interest in keeping the public safe. And if some people are allowed to yell fire in a crowded theater just for fun, people can get trampled on and then people will get hurt. And so the government can limit that. Back to freedom of speech, and we'll talk about this a little bit more later on. If people have freedom of speech, but are you allowed to, can the government limit your freedom of speech if you're trying to incite people to riot? Well, you can't incite people to riot. There are conditions, and I'll describe them more, but you're not allowed to incite people to riot. So when the government can demonstrate so if somebody's arrested and they challenge it, let's say they're arrested for something they said, and they say that their First Amendment the First Amendment protected them to say whatever they were saying, the government is going to have to demonstrate it has a compelling interest in limiting that kind of speech. But it doesn't just apply to freedom of speech. That's just the example that I use most frequently. So let's talk about different ones. Let's talk about freedom of religion. And in this case, we're going to talk about the Establishment Clause. Now, once again, the Establishment Clause refers to the idea that the government is not allowed to show favoritism to any religion at all. They cannot show favoritism. Now, again, before selective incorporation, before they applied that to the state governments, states could establish religions. There were some states that had state religions. But once the courts said that this part of the First Amendment not only limits the federal government, but the state government as well, then states were limited as well. And so I just want to go through a couple of court cases. Now, I don't have the exact court case names, and in some cases there have been multiple court cases, but I want to give you an idea of the Establishment Clause and what the courts have said. So, for example, if you look at it, for those of you who can read, in italics it says, note in the blank spaces below, write constitutional if the courts permitted it and unconstitutional if the courts did not permit it. So, prayer in public school. Can a school require its students to say a prayer at the beginning of each day? There were court cases where people sued because they said the schools are requiring people to say a prayer. The First Amendment says, the Establishment Clause says the government cannot show favoritism, and the courts have agreed. Prayer in a public school especially what they call captive prayer, where you're in a classroom and you have to pray, that's not constitutional. That is unconstitutional. Well, what about student-led prayer? We're talking about public schools only, because private schools are not, it's not a government entity, and so they can do whatever they want. Public student-led prayer in public school, like before a high school football game, that's constitutional, right? If it's student-led prayer, so those of you who played sports, I've heard this from former students before, that before a game, the students would get together and they would say a prayer, collectively say a prayer, right? As long as the coach doesn't lead the prayer, it's entirely constitutional, because it's not the students being required to do something. What about a moment of silence before a high school football game? Well, that's constitutional, because nobody's being forced to pray in any way. Yeah, it's a public high school, but people can do whatever they want in that moment of prayer. That is constitutional. What about displaying religious symbols on public property? So there were two cases going on at the same time in different parts of the country. One was happening in Alabama, one was happening in Texas. I guess those are kind of the same part of the country, the South, but in any case, that's not relevant. Here's what was happening in Alabama. The Chief Justice of the state Supreme Court had paid for the building of a sort of granite statue of the Ten Commandments. And when the statue was done, the Chief Justice of the state Supreme Court in Alabama put it in the center of the court building, so when people walked in, they would see this beautiful statue of the Ten Commandments. Somebody saw that, and they sued, because they said this was a violation of the Establishment Clause. This was essentially the state of Alabama endorsing the Judeo-Christian religion. Both Judaism and Christianity rely on the Old Testament. The Ten Commandments come from the Old Testament. And so the people who sued said this shouldn't be in here because it's a violation of the Establishment Clause. This is the state of Alabama endorsing one religion over another. At the same time, there was another court case that was happening in Texas, and this was different. In this case, what had happened is the state of Texas had built a park. And in this park, you walked through the park. It was a big park because it was Texas and everything's big in Texas. And so you walk through this park, and in the park, as you walk through the park, it showed different parts of the history of Texas. And in one part of this park, there was a section devoted to the missions and the role of the missions in Texas. And in this part of the park that was devoted to the missions, there was a mission with a crucifix on the top. And again, somebody sued, and they said this is essentially the state of Texas endorsing the Catholic religion or the Christian religion, hence the crucifix on there. This is the court saying, this is the state of Texas saying, this is our preferred religion, Christianity. There wasn't a Jewish star there. There wasn't any other symbol of any other religion, just the crucifix. Well, both of those cases wound up being settled by the Supreme Court. And what they wound up saying was that the religious display in the Alabama courthouse, the Ten Commandments, that was unconstitutional. And they said that the display in Texas was constitutional. And here's why. They said the display in Alabama, the Ten Commandments, that actually was an endorsement of a moral code to the exclusion of other faiths. You know, the Hindu faith wasn't represented, the Muslim faith wasn't represented, the Buddhist faith wasn't represented. There was nothing else other than the Judeo-Christian faith represented. And in doing that, that was essentially an endorsement of a religion, one religion, and that was unconstitutional. But they said that the display in Texas did not have a religious purpose. It had a secular purpose. Now, for those of you who don't know what the word secular means non-religious. And the point that the court was making was that the display in Texas was to teach about the history of Texas, not to proselytize or teach about a particular religious faith. And that you couldn't really tell the history of Texas without talking about the missions. Same is true about California. If you want to talk about the history of California, you have to talk about the role of the missions. And so in a case like this, what the courts did is they said, religious display in Alabama, unconstitutional. Religious display in Texas, constitutional. And the difference being was that one had a religious purpose and one had a secular purpose. And what this did is it provided guidance for future court cases. So if a court was faced with a question about a religious display on public property, this would be one of the precedents that they would look to. The court's decision in the Alabama case, as well as the court's decision in Texas, right? And then they would, following the doctrine of stare decisis, use the same reasoning. And the next one we'll talk about other kinds of civil liberties in the next video.